Thank you for coming today. I'm attorney Gloria Allred, and to my left is our client, and she will speak after I speak. She will not be taking any questions. I will take a few questions. To my right is my partner, Dolores Leal, and Dolores will also be meeting with the Spanish language press immediately following, and this entire statement, my entire statement, will be delivered in Spanish. My client will also be delivering her statement in Spanish at the conclusion of our English language news conference. Also standing behind me is my partner, Michael Morocco, and also standing beside him is another attorney whom I will introduce in a little while. So we are here today so that Meg Whitman's nanny and housekeeper, Nikki Diaz-Santillon, can talk about what it was really like to be employed by Meg Whitman in her home for 9 years. In short, it was a nightmare. And the way that Nikki was treated by her employer, Ms. Whitman, caused Nikki to feel exploited, disrespected, humiliated, and emotionally and financially abused. It also made Nikki feel that she was the victim of hypocrisy. The relationship was terminated last year by Ms. Whitman for what appeared to be political reasons involving Ms. Whitman's decision to run for governor. In August 2000, Nikki was sent by an employment agency to interview with Meg Whitman for a job as a housekeeper. In this interview, Nikki alleges that Ms. Whitman never asked if Nikki was here legally. Nikki was hired and was told that she was required to work 15 hours a week, cleaning the 3,700 square foot house, and would be paid $23 per hour. After Nikki began to work for Ms. Whitman, nanny duties were added to her job, which included driving to the grocery store, cleaners, shoe repair, school, library, children's friend's house to take and drop off children, and to the airport to drop off Meg Whitman's husband, Dr. Harsh. Although Nikki alleges that she explained that she could not do all of the housekeeping and fulfill all of the added responsibilities in 15 hours a week, and that she was working more hours than that, trying to do all of those jobs, she alleges that she was told that 15 hours a week was all that she would be paid for. In short, Ms. Whitman failed to pay her for all hours that she was required to work, and failed to pay her mileage reimbursement for using her car for the errands that Ms. Whitman required her to run. In addition, even though Nikki asked for a raise some years back, Ms. Whitman refused to give her one. In addition, when Nikki indicated to Ms. Whitman in March 2005 that she needed to take a medical leave for pregnancy, she alleges that she was told that unless she herself obtained someone to replace her, that her job might not be there for her when she returned. Had Nikki filed a lawsuit of pregnancy discrimination at the time, and had she been able to prove her allegation against her employer, this treatment would constitute unlawful pregnancy discrimination. Despite extremely difficult and what she believed to be unfair working conditions, however, Nikki continued to work for Ms. Whitman because she believed and because she desperately needed the job. She also filed no claims because she had no idea that she had any right to do so. Throughout her employment with Ms. Whitman, Nikki was undocumented, and she alleges that Ms. Whitman was aware of her status and may have understood that Nikki was vulnerable as a result of it. Not only did Ms. Whitman fail to ask her for documentation, but on several occasions when Ms. Whitman asked Nikki if she went to Mexico for vacations, she alleges that she would tell them, quote, "I cannot travel outside of the country," end quote. Further, on April 22, 2003, Ms. Meg Whitman and her husband, Dr. Harsh, received a letter from the Social Security Administration office indicating that the Social Security number that Nikki had provided did not match Nikki's name. A mismatch of a Social Security number to an employee's name is a clue that the employee may be undocumented. That letter instructed that, quote, that the employer was required to do the following, quote, compare the information shown above to your employment records. Ask the employee to give you the name and Social Security number exactly as it appears on the Social Security card, and goes on to say that the employer is required to return this letter in the enclosed envelope, end quote. Instead, Nikki, the employee, was told to, quote, check on this, end quote. The employer, however, never asked her about this again, and we believe never returned the letter to the Social Security Administration. Nikki also alleges that for several more years, Ms. Whitman continued to receive letters from the Social Security Administration office regarding the mismatch in the Social Security numbers. She alleges that she saw these letters after they were thrown in the trash. Ms. Whitman never asked Nikki about the mismatch. Was Ms. Whitman engaging in her own form of don't ask, don't tell, so that she could continue to benefit from the work of a vulnerable and undocumented worker and exploit her while pretending that she didn't know the truth about Nikki's status? Nikki's employment with Ms. Whitman finally came to a sudden end in June 2009. In April 2009, Ms. Whitman told Nikki that she had officially announced her campaign for governor. It was at this point that Nikki decided that she would speak to Ms. Whitman for help to legalize her status. Nikki felt that because she had been loyal to Ms. Whitman, her husband, and their children, and had worked hard for them, that Ms. Whitman would agree to assist her. In June 2009, she finally managed to make an appointment with Ms. Whitman to speak to her about it. Nikki will describe the conversation that she had with Ms. Whitman and her husband, Dr. Harsh, that day. I will simply state that when Nikki asked for help, she was terminated. The inconvenient truth of the hypocrisy of Meg Whitman, as illustrated by her employment of an undocumented worker and her exploitation of her, was going to be revealed because Nikki wanted to be legalized. Therefore, the fact that Nikki was employed by Meg Whitman and her husband when she was undocumented would become public knowledge. Until she decided to run for governor in 2009, it appears that Ms. Whitman had no problem or concern about employing an undocumented worker. Apparently, she knew that employing an undocumented worker while running for a high-profile public office was a potential liability. A few days later, in an act of what appeared to be political damage control, Meg Whitman fired Nikki. Don't ask, don't tell may have become, oh my God, she will tell if I continue to employ her. The loyal employee of 9 years is now persona non grata with the Whitman household. Nikki was terminated in a sudden, cruel, and heartless way. It takes a great deal of courage for a person in Nikki's position to speak out against her former employer. She understands the risk that she is taking. Because Ms. Whitman has power, money, and influential contacts, she understands that Ms. Whitman may try to retaliate against her. Nikki has been willing to take that risk because she feels it is very important that the truth about Ms. Whitman and her cold and heartless treatment of a hard-working Latina is known. Nikki does not feel that either she or any other employee should have to suffer what she did as an employee of a wealthy and politically powerful employer. As a result, we intend to file a claim for the wages that are due her for the hours that she worked, for which she wasn't paid, and her mileage that Ms. Whitman never paid. We will file this claim with the State of California, Department of Industrial Relations, Division of Labor Standards Enforcement.